This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about why an insurance company's policy's private limitation of action provision can be and will always be enforceable. The Seventh Circuit Court of Appeals applied the contractual limitation of action provision in a policy issued by State Farm and found that the late filing of suit by the plaintiff breached that provision and the suit could not be maintained. In Waseem Daker versus State Farm, the United States Court of Appeals for the Seventh Circuit on February 3, 2023, dealt with the issue and found that more than a year after Daker suffered property damage, he sued State Farm Fire and Casualty Company for insurance coverage, despite the fact that he knew that his policies with State Farm required that he file suit within a year of the loss. The district court granted State Farm's motion to dismiss, and he appealed. The district court ruled that the policy's provision was enforceable and that Daker's suit was time-barred. Daker, who had been in prison in Georgia for over a decade, maintained ownership of a home in Georgia. According to Daker, the property was insured by State Farm, a company incorporated in Illinois. Daker alleged that two incidents warrant coverage. First, tenants abused and vandalized the home through June of 2017, and then, in January of 2018, Daker's brother burglarized the home, damaging it further. Daker filed two insurance claims with State Farm for the damage to his property, one claim relating to each other. State Farm denied both claims. In the denial letter, which Daker received in March of 2018, State Farm alerted Daker to the provision of his insurance policy that required him to sue within 1 year of the dates of damage, and it provided, quote, "suit against us. No action shall be brought unless there has been compliance with the policy provisions, and the action is started within 1 year after the date of loss or damage," close quote. About 2 years later, in February of 2020, Daker sued in a federal court in Illinois asserting diversity jurisdiction. As relevant on the appeal, he alleged that State Farm breached its insurance policy by declining coverage for his property damage. Daker conceded that he sued past the 1-year limitations period in his contract with State Farm, but argued that the period did not matter because, among other reasons, the provision was unreasonable and State Farm had misled him about it. After permitting Daker to amend his complaint 3 times, the district court granted State Farm's motion to dismiss it with prejudice. Moreover, Daker lacked a valid defense to the provision, given that State Farm told him of it in denying his claims. The 1-year limitation provision barred Daker's suit, which he filed nearly 2 years after the most recent date of property damage. Daker contended that his complaint was not time-barred because promissory estoppel, equitable estoppel, and equitable tolling defeated the limitations defense. Daker relied primarily on his argument in his motion for reconsideration that State Farm never delivered to him a copy of the policy that he said he needed to timely sue. He contacted his State Farm agent in early 2018 to ask for another copy of his insurance policy, and she promised to send it to him, but never did. Daker contended that he detrimentally relied on the State Farm agent's promise, so that promissory and equitable estoppel should toll the limitations period. Daker added that the equitable tolling also applied because he was unable for a time to access his prison's law library, which he also needed, he claimed, to protect his complaint. The Court of Appeal noted that under Illinois law, limitation rules and defenses to it are governed by the law of the forum, and Illinois' law regarding the validity of contract terms that displace statutes of limitations and tolling. Such a contract term is upheld if it was accepted knowingly and voluntarily, is reasonable, and is consistent with public policy. Georgia law, which Daker preferred, is similar. These provisions are generally enforced if they are not unconscionable or so unreasonable that they raise a presumption of undue advantage. An equitable tolling defense requires a showing that, despite exercising due diligence, Daker could not discover the facts essential to his claim within the limitations period. The court noted that the one-year limitation provision in State Farm's policy is valid and enforceable. The provision was reasonable because it allowed Daker sufficient time to sue after his dates of loss. He knew about the deadlines because State Farm notified him of the limitation in its denial of the claim, and it reminded him about the one-year deadline. Daker asserted he needed the policy to help him prepare his complaint, but with his own actions, he refuted that assertion because he successfully prepared and filed his complaint without the promised copy of the policy, and no one suggested that his complaint inadequately alleged breach of contract. He also based the defense on his inability to access his prison's law library, but he did not need the library to allege that State Farm breached his contract, which he told the court he knew when he received the letters from it declining coverage. In my opinion, State Farm took no chances with the litigious felon, Mr. Daker, by not only denying his claims in writing, but also warning him, as most state regulations require, that the policy contained a one-year private limitations of action provision, and that if he wanted to file suit, he had to do so within 1 year of the loss. Daker ignored the warning, and with the ingenuity of a jailhouse lawyer, claimed that equity required the limitation provision to be ignored because State Farm did not provide a copy of the policy and Georgia did not give him access to the prison law library. Both arguments failed. Without the policy or the law library, he filed an effective lawsuit that properly alleged breach of contract. He just filed it too late. Because the district court gave Daker 3 attempts to plead a viable cause of action, State Farm was required to pay a great deal of money to counsel to defend the allegations of the 4 separate variations on his lawsuit, and to defend the allegations and waste the time of the court, perhaps because Daker was bored after serving 10 years in prison with some more to go. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. And you can subscribe to the blog so that you will receive notice of each of the blog postings, usually 5 a week, sometimes more. And you can also subscribe to these videos at either rumble.com or youtube.com. And if you like them, please click on the Rumble button, which is a gloved hand, or the like button on YouTube. And if you found these videos and blog postings to be of interest or use to you in your practice, Please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. You might also wish to consider subscribing to my locals community and or my Substack publications, where for a small fee you will find many different variations and additional information on insurance law, insurance claims law, and how and when to deal with insurance litigation. Thank you for your attention.